Hearing the appeal, Energizer Supermarket Limited against Holiday Snacks Limited.
Yes, Mr. Hossain.
Thank you very much, my lords and my lady. Might I introduce myself? My name is Fayad Hussain.
I'm so sorry, say again?
My name is Fayad Hussain, and I appear for the appellant, and with me is Ms. Sasha Bujmohan Singh and Mr. Adam Hussain. And on the other side is my little friend, Mr. Christopher Suchan and Sonel David Long, who appear on behalf of the respondents. My lords and my lady, this is an appeal from a decision of the Court of Appeal of Trinidad and Tobago dated the 28th of June 2019. What I propose to do is to briefly rehearse the facts, and secondly, to give a summary of what our general propositions are, thirdly, to touch the issue of illegality, and fourthly, to deal with the issue of the easement, the license, or the constructive trust, as the case may be. And that's the order in which I'm going to address.
Thank you. You can take it, of course, that we've read your very full and helpful cases on both sides, yes, and the judgments of both the First Instance Judge and the Court of Appeal. So I think we have a reasonable understanding of the facts, but of course you'll want to summarize the highlights.
Yes, I do, Appellants. This case deals with area of Trinidad and Tobago called San Juan. It's located at the foothills of the Northern Range in the district of Aranjuez. There is a road that leads to San Juan called the El Socorro Road, part of our Spanish heritage. And in 1986, the facts relating to this case unfolded. On the western side of that road in 1986 was a parcel of land owned by a Mr. Boodhai. On the eastern side was a parcel of land owned by KISS. KISS is a baking company, and Mr. Boodhai lived on his property located on the western side. The facts begin in 1986 when there was an agreement between Mr. Boodhai and KISS relating to the construction of a 2-inch gas pipeline on the northern boundary of his premises, leading over the El Socorro Road onto the property of KISS. That's the 1986 agreement, and I will take you to that agreement in a little while. The next event that is of importance is that in 1994, the property of Mr. Boodhai, located on the western side of the El Socorro Road, was purchased by Energizer. And Energizer is the appellant in this case. Shortly thereafter, in November 1994, August 1994, Mr. Boodhai terminated the 1986 agreement. Meanwhile, in 1992, KISS purported to assign whatever rights it had under the agreement to its subsidiary, Holiday Snacks Limited, which is the appellant in this particular case. Respondent, I beg your pardon, in this particular case. Now, those are briefly the facts of this case. There's one other fact. In December of 1994, Mr. Boodhai said that Energizer's managing director, Mr. Boodoo, knew about the pipeline, but we submit nothing really turns on that as such. Now, what is it that our case is about? We say, first of all, that the 1986 agreement and thereafter the construction and operationalization of this gas line by KISS and or NGC is contrary to the provisions of the Petroleum Act and regulations. NGC is a government-owned company. It is not a statutory corporation. It deals with the distribution of gas in Trinidad and Tobago. It did not feature very much in this case until the issue was raised in the Court of Appeal, until for the first time, and there are no pleadings in respect of NGC except to the fact that sometime in 1992, I believe it was, KISS purported to indicate that NGC, KISS and NGC entered into agreement whereby NGC agreed to supply gas to KISS, subject to a number of conditions, one of which is that NGC would be the owner of the gas pipeline and related facilities. I'm sorry, it's 1986. Now, so therefore we say the construction and operationalization of this gas pipeline is contrary to the provisions of the Petroleum Act and the regulations. We say that the Petroleum Act provides a comprehensive regime for the regulation of, first of all, the pre-application for the construction of a pipeline, the application for the construction of a pipeline, for the construction of the pipeline, and for the maintenance and operation of the pipeline. It is a given in this case that neither KISS nor Mr. Boodhai or any one of them have a license under the Petroleum Act to engage in petroleum operations. Further, the respondent in this case has not been able to point to any person who had a pipeline license. Now, we say as well, KISS attempted to transfer some benefit under the 1986 agreement to Holiday Snacks Limited, and that Holiday Snacks Limited also does not have a license under the Pipelines Act. We say that in any event, that purported transfer under the provisions of the legislation, KISS not being a licensee and the respondent not being a licensee, the Act makes it null and void and of no effect. And therefore, really, the defendant has no locus, or the respondent has no locus to maintain the action. And that's the first point, the legality of the pipeline. The next point is a simpler point. We say that there is no equitable easement, and the agreement was personal to Mr. Boodhai and KISS, and could be terminated by either party, Mr. Boodhai or KISS, on reasonable notice. We say furthermore, even if the appellant had notice of the pipeline, we cannot glean out of that any constructive license, any constructive trust of KISS or its successors, since the parties to a contractual license of purchase property with notice or without notice are not bound by a contractual license. We say furthermore that no interest pass to the respondent under the Conveyancing on Law of Property Act. We say finally that the special circumstances in which the conscience of the transferee, that is the appellant in this case, has not been affected. There are no exceptional circumstances. There are no special circumstances which would meet the legitimate expectation of a third party to qualify as any kind of constructive trust. And we maintain the fact that there's a contractual license between KISS and Mr. Boodhai could be terminated by them. So what I will do first of all is elaborate on the issue of illegality. And my lords and my lady have read the papers, but I could just point to a number of sections which might be important. The first section is section 6, and it brings into play the concept of petroleum operations. And a person cannot engage in petroleum operations on land or in the submarine area unless he first obtains a license under the Petroleum Act and regulations. And that is very clear under Section 6.
Have you got the electronic page number?
Yes, my lord.
For that section, please.
The electronic page number is EB97, EB97 5, EB975.
Yes.
Right? And we say that petroleum operations, which is at EB973, includes the transportation of gas through a pipeline, and the construction as well. And that is reinforced, my lord, by Regulation 3.1, and that regulation is found at EB1001. And in the regulations, it provides expressly that a license must be applied for, a pipeline license. There's specific reference in Regulation 3. It's at EB101, and EB1001. And it says as follows: subject to regulation to which doesn't apply here, licenses may be issued to persons to engage in petroleum operations and shall be F, a pipeline license, and G, transportation other than a pipeline license. So out of these provisions, we say that in order to engage in petroleum operations, you must specifically apply for a pipeline license. Now, it is not a mere
relevant here, or are we only talking about F?
We are dealing here with F, but I mentioned the other provision because it says other than a pipeline license. So I thought that might be important because it reinforces F. Now, yeah, so we go a step further. It's not only the issue of the application that is regulated for a pipeline license, but there is a process by which there's an objection process, which is found in Section 8.1 of the Act, which is at EB 976. A person may lodge an objection within 30 days at Section 8.3 at EB 976, and objections have to be considered by the minister, Section 8.3 at EB 976 again, and the minister can only grant a license after considering an objection and publish such approval in the Gazette at Section 9.1 and Section 2. So there's a process by which a pipeline license is granted, if it is to be granted at all. Other regulations that are important is how you go about making this application. And that is dealt with particularly at Regulation 6. Regulation 6, which is at EB 1003. And it provides a number of ingredients that must be in place before you apply for a pipeline license. It's headed Form of Application for a License at 1003. So you first of all have to describe yourselves at 6A, name, nationality, etc., nature of the business. B, the type of license for which an application is made. So in this case, a pipeline license. Where applicable, a description of the site or project, as the case may be, illustrated by a plan or a map to be prepared to such a scale as the minister may require of the situation, boundaries, and area. And more importantly, the parcels of land with respect to which the application is submitted, and in the case of land referred to in 2.3 of the Act, such as the particulars as may be required in order to identify them. And we go to I, in relation to applications for pipeline license, and more specifically, for the installation and operation of a new trunk pipeline, the route, the length, the diameter, and other particulars to be shown on the map of the proposed pipeline is boundary lines, the names of the owners of the land over which it would pass, the location of the pumping and terminal station and their capacities, the estimated cost of construction, etc., etc., etc. So this regime...
Sorry, just on I, doesn't that show that if a pipeline is going to be laid, you need the property rights to enable you to do that over the land of particular people?
Yes, my lord. I accept that absolutely. And this is where we go to the question of ancillary rights. Perhaps I can touch that very briefly now.
But
if I go to
all right.
Regulation 12, sorry, Section 25A, 25B, I beg your pardon. 25B, which is at EB 984, where a license is granted and ancillary rights are required by the licensee, he shall, in accordance with any other written law relating to land holdings, negotiate with the state, etc., etc. In any other case, the person entitled to grant the rights for grant of such rights. So therefore, a license, the ancillary rights flow only when a license has been granted. So out of these provisions, I glean the following. What you do is you do a topographical survey first, and provisions for topographical survey is provided for in Regulation 12, and it's at EB 1006. Any person desiring to construct a pipeline for the purpose of conveying petroleum or petroleum products or other substances prescribed by order shall apply to the minister for a permission to carry out a topographical or other survey with a view to selecting the route of the proposed pipeline. So I think
forgive me for interrupting. Yeah. Why can't you negotiate for relevant rights before you get a license?
You can do so, my lord. But
right.
if you're exercising the issue of ancillary rights, you need to get your license. So there is absolutely nothing wrong with negotiating and getting conditional permission, as the case may be. So in a typical situation, in this kind of setting, what you do is you probably negotiate. You probably have some kind of conditional agreement, subject to approval. You apply to the minister. He may say that the negotiations in respect of a particular route, he can't approve it, as the case may be.
But why do you need to negotiate a conditional agreement? So just in pure terms of property rights, what's to prevent you agreeing that you will have a property right? It may be that if you don't get a license, it'll be a useless property right that you've acquired. But why can't you acquire a property right which may assist with your application for a license later?
You can do that. It's perhaps not prudent, but I accept the fact you can do that. You can negotiate a property right before if you wish, but it would not be an application that is enabled as a consequence of the exercise of ancillary rights.
No, but you don't need, if you can do it as a matter of ordinary
I accept that, my lord.
Agreement on property rights, you don't need to rely on Section 25.
I accept that, my lord. I accept that.
All right.
Does NGC have to go through this process if it wants to build a...
Yes, my lady. NGC has to go through the process as well. They all have to undergo the process. The regime is developed in such a way that if you don't need a pipeline license, if you're operating within a pre-approved area, like for example, if you are undertaking drilling operations in a particular area and the area is demarcated, you don't need a pipeline license there. But if it is that you are doing a new route, as the case may be, as in this particular case, what you have to do is to get a pipeline license. And NGC is included among the persons, is like any other citizen or person, is entitled or has to apply for a pipeline license.
What do you say the position would have been if, after making this agreement, KISS had applied for and got a pipeline license?
I would think, Millard, that that is possible, but it is not contemplated by the legislation because of the fact that there is a process that begins with a topographical survey. There's a process of application. There's a process of the minister pre-approving the construction of the pipeline, the dimensions as the case may be, the technical aspects of the pipeline, and all of that. And therefore, it is not something which I think should be encouraged or permissible at all, because before you actually put a pipeline down.
Well, you accept it's possible, even if it's not to be encouraged, which seems to me it plainly is, and that shows, doesn't it, that the making of the agreement could not itself be said to be contrary to any law.
Except the agreement itself makes provision for the laying of a gas pipeline.
Well, maybe it does, but if there's nothing illegal about agreeing that, if you may well have a license when you've got the when you lay the pipeline.
Well, in this case, I mean, in any event, in this case, there's no license on the part of KISS, no license on the part of Holiday Snacks. There's absolutely no license at all. So,
but did Omega Fabricon have a license?
They were merely dealing with fabricating, not with the ownership of the route.
No, they didn't own the route, but they are the ones, according to the agreement, that were actually going to physically lay the pipeline.
No, there's no license in respect of Sookram. No one had a license in this particular case, my lady. And that is not in dispute. There's, up to now, no one has a license. It's an unregulated pipeline.
I'm still struggling to see why that matters. As I understood your answers to my Lord Legate, you accept that there can be a prior agreement for the grant of an easement or way leave over land before an application is made for a license.
Yes, my lord.
And we have here an agreement for an easement or a way leave, or so it is said. I appreciate you challenge that, but assuming it is an agreement for an easement, which is obviously made before the pipeline is put down, what's the difficulty? I can't see that the fact that later on things happen that may have been affected by illegality infects the original agreement with illegality and makes it unenforceable or in some way a matter which you can impugn.
Yeah. Let's, if you look at section 25 of the Act.
Yes, I've got it in front of me. It's page 984.
Page 984. Where a license is granted and ancillary rights are required by the licensee.
So just pausing there,
Yeah.
we're dealing with a situation before that.
Okay. Well, you can't...
Section 25 just,
Yes.
I can't see that it applies.
No, let's assume for the moment I accept that, and I accept it, Millard. I accept that. But in this case is not only about the question of the negotiation for an easement or a contractual license in respect of the pipeline. It deals with also the issue of the construction of the pipeline, which dimensions have to be provided to the minister. It deals with the operationalization of the pipeline. It deals with the maintenance of the pipeline and the defense and counterclaim. And even the statement of case itself deals with those issues. So therefore, respectfully, the Court of Appeal concentrated its reasoning on the issue of the pre-application. That is the pre-application relating to the negotiation and conclusion of the agreement and did not go beyond that. And therefore, the reliefs we asked for go beyond the issue of the negotiation of the easement, but it goes to the issue of the construction, the maintenance, and the use of that pipeline.
But the agreement itself is just between KISS and Mr. Boodhai.
Yes, my lord.
Mr. Boodhai will allow Omega on behalf of KISS to construct a pipeline. Doesn't that leave open the possibility that either KISS or Omega can apply for a license thereafter and may get one?
Well, my lord, it depends on how you construe the regulatory regime, which is set out in terms of the application being made. If you construct a pipeline, and of course, a pipeline is buried into the ground, and you cover that pipeline, and there's a regulatory regime in respect of the size and dimension of the pipeline, the safety requirements, the maintenance requirements, and all technical aspects comprising the pumping station and what have you, and some of these, the valves and all of that. I would hardly think that the approval of a pipeline post-construction without the benefit of a license can stand respectfully, because the minister has to determine the route. The minister may say, look, I don't particularly like a route, as the case may be. He may afterwards, but he has no way. It makes the process difficult.
If I may say so, I follow all of that. I can see that there may be a difficulty in terms of the regulation regime about the actual construction of the pipeline, but we're dealing with an agreement before any of that's happened. It's looking forward to something that may happen, and I think you have already accepted that it would, at least in theory, be possible for KISS or Omega to have applied for a license. Maybe they didn't do that, maybe that's wrong, but it was conceptually possible for them to have both this agreement, the 1986 agreement, which just made absolutely sure that KISS would have the rights that they would need if they were going to get a license, because a license without the property rights would be useless as well. So they need to get those in place. And then it is looking forward to the construction of a pipeline, but the license might have been acquired in time for that to happen later on.
No, that can be possible, but what you're doing there is you can't invoke Section 25.
No, but you don't need. So that's what I've been putting to you already. You don't need Section 25. We're arguing about property rights. Yes. And the question is whether the property rights have been acquired, and KISS are saying, or Energizer, Happy Snacks, Holiday Snacks, forgive me, are saying, well, we got the property rights because of the 1986 agreement. Before ever the pipeline was constructed, we had the right to construct a pipeline, just purely as a matter of property rights over Mr. Boodhai's land.
My lord, I'm asked to look at I'm asked to look at 25 again.
Yes.
Where license is granted, ancillary rights are required by the licensee. He shall, in accordance with any other written law related to landholding, negotiate with, in any other case, the person entitled to grant the rights for a grant of such rights. Right? Now, I accept what my lord says, right. But however, you can't use 25 in those circumstances.
No, because you haven't got a license, but you don't need to.
But you haven't got a license.
I mean, it might be said Section 25B is somewhat against your case, because that clearly contemplates that in order to make a license capable of operation, you need the relevant property rights as against the owners of land that you might need to use to make the license work. And Section 25B says, well, if you do it in the order, you get your license, and then you try and put the property rights in place, well, you have to negotiate with the people who have the property rights that you need.
But isn't it leading up to Section 25 to a compulsory procedure if you don't get agreement?
I accept that, my lord, but except that the licensing regime is structured from the pre-application stage, so therefore it is a requirement to do a topographical survey. And therefore, I draw from the extensive licensing regime that if you embark on this agreement outside of the legislation, right, what you're doing is you're acting outside the legislation, of course, but the legislation contemplates a rigid adherence to every aspect of petroleum operations. That is from the issue of the application for to do a topographical survey and continuing on to ancillary rights. So there's a process. But if you go about the issue of merely just negotiating with persons to get rights as the kind here, what you have is you're beginning to act outside the very detailed regime that is contained in the petroleum Act.
Well, there's nothing to say, and you can't suggest, surely, that the Act says you're not allowed to acquire rights except from other people that you need, except under Section 25 and following.
No, I accept that, my lord.
Isn't Section 25 really saying, just because you get a license, that does not grant you any rights over the land that you may need in order to implement that license, even if it's state land, so that even though the state is giving you this license, it doesn't inherently include any land rights. You have to negotiate those either with the state or with whoever's entitled.
I accept that absolutely, Milady. I accept that absolutely.
Right. So I think it follows from the answers you've been giving us helpfully that two things need to be in place if you want, let's say, a pipeline. You need the relevant private property rights to run the pipeline over the land. You might do that by buying the land. I mean, here we're dealing with what's claimed to be an easement, but the land could have been bought. You just need some relevant property right which enables you to put the pipeline across the land. And so there's no other owner that can say, well, that's my land. So you can't put a pipeline across that. So that's something that you need. And then you need a license as well. And these are two essentially separate things.
I accept that, my lord.
And we're dealing with the former. And although you say, well, in the licensing regime, which deals with the control of the the public regulatory regime for control of petroleum operations, you need a survey and so on. Well, you can have a survey of land that you own. You can have a survey of the easement site.
I accept that as well.
It's just that if you do things in a different order, you might run different risks. So if you get your license first, and then you rely on Section 25 to fill in the private law rights afterwards, that may cause problems for you. That is a way of doing it. But there's nothing in Section 25 or the Act that says you can't do it the other way round. Sort out your private rights first so that you're not going to be held to ransom by anyone or encounter unexpected difficulties so far as that's concerned, and then apply for your license. Now, obviously, doing it that way round, you run a different sort of risk that you've sorted out the private property rights. Will you get a license going through the regulatory regime? You may or you may not, but it's a matter for you to assess whether you want to structure the risks you're going to run for this enterprise in one particular way or another particular way. But
I accept it absolutely, Miller, except that but I put this right at it. I think the critical juncture is where you start the issue of the construction of the line, the gas pipeline, because at that point is where the mandatory regulatory provision kicks in.
Right.
Nothing, sorry if I can ask, there's nothing in the agreement, is there? It's never been suggested that it's some sort of implied condition of the agreement that you have to have a licence for the line, for the gas pipeline. I mean, the parties haven't prescribed, well, this will only be effective if you get a licence.
Well, I was wondering about that because it does say all safe, this is page 256, all safety features will be adhered to, but my Lord Legate's right, there's nothing express in the agreement that says it's an implied term that, of course, you're not going to be acting illegally when you lay this pipeline on my land, thank you very much. But I think the difficulty with that is that my understanding is that it doesn't involve any liability on the part of Mr. Boodhai or Energizer if this pipeline is actually an illegal pipeline. Nobody's going to come back for them with any repercussions for that. So I'm not sure whether it would be necessary to imply a term.
Well, I put it this way, we have to separate the issue of the acquisition of this license or easement, as the case may be, which is one issue that is regulated but can be done before you apply for your license, and that's fine. The second thing is the agreement itself provides for the construction of a 400-feet pipeline of 2 inches for the purposes of supplying gas. And it is at that point, at the very latest, that the legislation is triggered, because you need to have your technical specifications in a license approved by the minister before you do that. Now, if you wish to lay a pipeline on a piece of land on which you have a license or easement, as the case may be, and you say, look, this is for purposes of the transportation of gas and for petroleum operations, I think that the minister is required to approve that. If it's a water line, it's a different thing. That falls under a totally different licensing regime. But the minister would want to, under the legislation, consider and give his consent or disapproval, as the case may be, in respect of a gas pipeline. So the issue is whether you can enter into a license or easement for the construction of a gas pipeline outside of the regulatory framework prescribed by the legislation.
I think you've accepted that you can, but your argument amounts, doesn't it, to saying that it's contrary to public policy for the court to enforce this agreement if, in the circumstances which have happened, there isn't a license for the pipeline.
That is so, Millard. That is so. Because the express provision in the agreement was for a gas pipeline. It's for a gas pipeline, which has been operationalized. Now, we say that it is one thing to acquire property rights in anticipation of getting a license. It's another thing if you wish to enter into this agreement for the purposes of constructing a 2 inches thick, 400-foot 400 feet gas pipeline in pursuance of this agreement. And this is where it becomes gray, because can you really do that and then proceed to construct the pipeline without a license? And that is a difficulty, because once the cat is out of the bag, proverbially speaking, ministerial approval is cast out of the window, as it was in this case. In other words, Mr. Boodhai and KISS should not be able, under the licensing regime, to enter into a private, secret agreement between themselves to construct a gas pipeline when that issue...
I don't think that argument is open to you, to say they shouldn't agree to construct the pipeline once you've accepted, as you have, that it's perfectly possible to make that agreement validly and then get a license. What it seems to me you have to say is what I put to you just now, that if there's any argument, it must be that it's contrary to public policy for the court to enforce the agreement in a situation where the person who ran the pipeline is breaking the law
Yes.
in doing so.
Yes, my lord, I accept that absolutely. The agreement is one thing, but the issue is, well, the construction, if you wish, the construction of the pipeline itself, and this is where the issue is, and the licensing regime connected with the construction of the pipeline.
We don't know what anyone's intention was, and maybe Mr. Boodhai didn't know whether KISS were intending to apply for a licence. He may not have cared whether they were or not. So at the time the agreement was entered into, it may have been unclear what everyone's intentions were as regard to the licensing regime.
Well,
but it's difficult to see how the fact that they constructed it without a licence can somehow retrospectively invalidate it unless one goes down the path that my Lord Legate suggests.
Well, Mr. Boodhai and KISS, if I might take you to the agreement, which is found in electronic bundle
256. I think.
256. Yes. 256.
That's the agreement.
That's the agreement, yeah. It's headed supply of natural gas. So it advertises upfront what this is about. Wish to advise that our company agrees.
Sorry, where are you reading from?
Sorry, supply of natural gas.
This is the agreement.
Oh, sorry, I beg your pardon. I'm reading the wrong document.
Yeah.
KISS Baking Company Limited, 3rd of March, 1986. This is an agreement between KISS and Sookram Boodhai. Mr. Boodhai agrees to allow Omega Fabricon Limited to lay a 2-inch gas pipeline. A 2-inch gas pipeline. So Mr. Boodhai had to know, respectfully, that this is an agreement relating to the laying of a 2-inch gas pipeline, a length of about 400 feet through his property. This pipeline connection is for the benefit of KISS Baking Company Limited. And it says where it is going to be laid, and it says that Mr. Boodhai also agrees to allow an approved agent of KISS Baking Company to conduct repairs to the gas line under his property should any repairs become necessary in the future. And all safety features as required by the Trinidad and Tobago Natural Gas Company will be adhered to. And they are the suppliers of this gas. So respectfully, both parties knew at the material time that this was a gas pipeline for the supply of natural gas to KISS. And it is that issue, that is the construction of that pipeline that triggers, as Milord says, the issue of the public interest and the issue of whether it is that they can deviate from the statutory regime in the public interest to construct a pipeline and operationalize the pipeline. And that is reinforced at page 257, electronic bundle 257. And there's a letter of the 16th of September, 1986. And it demonstrates very clearly what is operating in the mind of KISS. And that takes off from the penultimate paragraph of the 3rd of March, 1986. And it says, we wish to advise, it is written to the, it's electronic bundle 257, yeah?
Sorry, this seems to be a letter to KISS.
Yes, is it from NGC?
Yes, it is, I think.
Sorry.
Yes, I can't see the signature. We only seem to have the first page of it.
Yeah,
Because then we get to another letter from KISS to
Yeah.
NGC, but that's years later.
yeah. I think there's a problem in the record. It's 257 continuing at 259.
Well, 258 is a letter of 1990.
Yeah, what happened is that.
Oh, I see what you mean.
A better copy of it?
It's got sandwiched between the two pages.
Yeah, yeah. There's a better copy at
Yeah, thank you.
EB33, I'm told. EB33.
33.
Yeah,
Oh, there seem to be 3 pages.
33.
Oh, yes.
Yeah. EB33, right? So this is a letter addressed to KISS, and it's signed by both NGC and KISS, as the case may be. And this letter came after the agreement with Mr. Boodhai, the 3rd of March, 1986. And it telegraphs very clearly what this was about. So therefore, in my respectful submission, KISS knew at the very inception that this was for the supply of natural gas. It says the supply of natural gas to the facilities will entail the construction of a pipeline and metering facilities. All costs associated with these facilities would be to your account. The pipeline and metering facilities would be owned, etc., maintained by NGC. And it speaks about the delivery point and what have you. So therefore, the parties, when they entered into the first agreement of the 3rd of March, 1986, knew that they were entered into ought to have known that they were entered into an area which was regulated by an act of Parliament, and therefore...
At what point does the ownership of the pipeline transfer to NGC? Is it always owned by NGC as soon as it's laid?
No, there's nothing in the letter of the 3rd of March, 1986 to say it is going to be transferred to the NGC, as the case may be. The first instance we have of that is on the 16th of September, 1986.
But when was the pipeline actually installed?
The pipeline was done in the regnum. That is between March 1986 and September 1986.
Oh, was it? How do we know that?
In fact, that doesn't look right, because point 1 in the letter of 16th of September is looking forward to future construction.
Yeah.
So that doesn't seem right. So I'm looking at page 257, point number 1.
257.
This is the letter you took us to from NGC to KISS.
Yeah. Well, it might be that there's no exact date on which this pipeline was constructed, but certainly I accept that. But certainly by the 16th of September 1986, there was a clear indication to at least KISS, or clear indication by KISS, expressed in a letter to NGC, that it was going to be used for purposes of the transportation of gas.
I don't see anyone's suggesting that it wasn't very clear to Mr. Boodhai and to KISS in March 1986 that this was going to be a gas pipeline. The question is what they knew or cared, if anything, about what licensing regime was going to be, or what licenses were going to be applied for and acquired. It's obviously not a condition of express condition of the March agreement that licenses are acquired, and it doesn't seem that the payment of the $12,000 is in any way conditional on that, or on the pipeline actually being laid at any particular point. So,
put another way around, I don't think you have a case, do you, that when the parties made this agreement, they were deliberately setting out to break the law and to construct an unlawful pipeline?
Well, if I accept that, if that's the preliminary view of the council, Privy Council, but what it is that the events that subsequently transpired is that they constructed and operationalized this pipeline without satisfying the regime required by the legislation, and that is what the second part of this case is all about. Because the second part of this case is not confined to this easement alone, but it deals with the issue And if I might just refer you to the defense and counterclaim, it deals with the issue of the operationalization of the pipeline. What page? The defense and counterclaim.
But if it was being operated by the National Gas Company and they had a licence, why was there any breach of the law anyway in the operation of
the National Gas Company had no license in relation to this.
It had no licence.
Very difficult to believe that Omega Fabricon, which is in the business of laying pipelines, and that the National Gas Company were all then conspiring to operate this illegal gas line.
Well, Millie, this is 1986. Could I just deviate for one moment and indicate this?
What's the significance of that?
Significance is the regulatory regime was lax at that time, but can I just say this? Can I just say
Lax,
this?
do you think you should?
Yeah, can I just say this? There's an application in, well, first of all, there's an elaborate application which I've spelled out, and there's an application in 2012 of how this process is undertaken. An example, the gazetted and whatever. Let's deal with the issue here about the question of the licensing regime. We are very clear that KISS had no license. That's number one. We're very clear that Holiday Snacks doesn't have a license. The third thing is that for the first time, the Court of Appeal raised, without the issue being in the pleadings at all, and without the issue being argued at first instance, because all we are left with was the provision in Electronic Bundle 256, where NGC will be required to adhere to all safety features and the supply of gas by NGC on the 16th of September 1986. So the Court of Appeal raised this issue and said, hold on, the construction of the pipeline, or the negotiations for this license or easement, and the construction of the pipeline is one thing. The question of the operationalization of the pipeline, which requires a license, and respectfully, we say it's more than just the operationalization. We say it's the construction, it's the application for the license, is the whole spectrum of events that are regulated under the provisions of the Act. So they raised for the first time that NGC might have a license, and they are not concerned about that. That's a matter for NGC. So in 2019, we issued a Freedom of Information request. And this is, my friend is objecting to this bit of evidence here, and we got the information which we have provided to the council by letter. We were tardy in terms of providing it. And GCC says, look here, we have looked into our records and we have no license in respect of this issue. I must mention my friend is saying this is new evidence. But insofar as the fact it was raised for the first time by the Court of Appeal, where they sought to segregate the issue of the negotiation for this license or easement from the construction and operationalization of the pipeline, we now have the information from NGC under the Freedom of Information request that no one has a license whatsoever. And that ties in with what we say in the pleadings, because if I can take you to the pleadings, first of all. What? EB12, Electronic Bundle 12. This is what, no, it can't be EB12.
I mean, if I may say so, just before you go there, just while the thought is in my mind,
Yeah.
I'm not sure we're in a position to, tell how lax or otherwise the application of the regime was in 1986, but excuse me, I'm not sure that it helps you if it was lax, because if the relevant licensing authority is lax about applying the law, that can give rise to all sorts of other bases on which it might be said that doing something with, it may be, the knowledge of the regulatory authority, even without a license, is still lawful on grounds of legitimate expectation or something like that. So I'm not quite sure why this is helping us to answer the issues in the case.
Well, this is a matter that has two dimensions to it. The first dimension is the issue of, I said lax because I was asked to explain why is it they did not, why is it that the regulation was not enforced or adhered to. And I really don't know why it was not adhered to.
All right.
But I really don't know why. But I just wish to take you, Millard, if I may, I hope I've answered the question at page 8 and 9 of the electronic bundle. You will see from there that what is being asked for in the reliefs at page 7 is a declaration that upon the true construction of the agreement made between Kiss Bacon Company Limited and Sookram Boodhai, dated the 3rd day of March 1986, a predecessor entitled to Energizer Supermarket, a relief was granted to the said Kiss Bacon Company. All well and good. Let's look at B, at 2, a declaration that the defendant holds the land situated at Lampos 54 El Socorro Road, San Juan, subject to the equitable right of the plaintiff in respect of a relief of the gas line running across the said lands, I believe it was. But they go further than that. What they ask for is an injunction restraining the defendant, whether by himself, his servants, or agents, or otherwise, however, from interfering or in any way obstructing the supply of gas flowing within the said pipeline so as to deprive the plaintiff, and an injunction restraining the defendant, whether by himself, his servant, or agents, or otherwise, from unlawfully interfering or tampering with the pipeline with the purpose and effect of causing damage to the plaintiff's trade on business. Now, those two injunctions, when coupled with what the counterclaim says, the amended defense and counterclaim, it says at page 9, it says at page 9, paragraph 5. The plaintiff denies, as alleged in paragraph 18 of the defense and counterclaim, the said Sookram Boodhai determined the said agreement on the 18th of, sorry, I'm reading the amended defense and counterclaim. I have to read the counterclaim. What page? 45. I beg your pardon.
Page 45.
45, yes. It starts at 40. It starts at 42. Sorry. And this is the case for the defendant on the counterclaim, amended defense and counterclaim. Further, on the alternative, the defendant will contend that the submerged gas pipeline described in paragraph 4 of the amended statement of claim was laid by Kiss Bacon Company's servants and agents prior to and without making an application to the relevant minister for a pipeline license under the provisions of paragraph 3, which I read before. B, obtaining a license in accordance with section 4 of the Petroleum Act and the petroleum regulations. So we complain, our complaint is not founded only on the agreement entered into between Mr. Boodhai and KISS. It is founded on a larger platform than that. 15, further in the alternative, if which is denied, the said Kiss Bacon applied for and obtained such license, the defendant will contend that such license cannot be granted for a period of more than 20 years, nor renewed for a period exceeding 10 years. Defendant will rely on Regulation 15 of the Petroleum Regulations. You see, my Lord, there's a 20-year limit in respect of a license. Further, on the alternative, the defendant will contend that it had no actual or constructive notice of the grant of any license, etc., etc.
That should be notice, not motive. Then.
Notice, yeah. 17. Further on the alternative, the federal contend that in addition to obtaining the license of case making, company was mandatorily required under the provisions of Section 39 of the Petroleum Regulations to secure the grant of a lease relating to the use of the lands prior to laying the submerged pipeline. And 18, further in the alternative, the federal contend that case making was not authorized to assign or transfer the benefit of any right or license accruing to it in respect of the submerged gas line on the said lands, that any such transfer or assignment which the defendant will put the plaintiff into the strict proof of is null and void of no effect. And further, or in the alternative, the laying of the submerged gas line by case making was illegal and not lawful, or any right, title, or interest in law it could not accrue to it. Further, which is denied, case-making company's successors are entitled to any right on the said land related to submerged. The defendant will contend that such a right was no more than a bare license, etc., etc. So we say, if I may summarize this, I accept the fact that a person who is engaged in petroleum operations might purchase land or enter into an agreement or obtain an easement or a license prior to the application of a license. And I accept that absolutely. The second issue is that that person, that applicant, will suffer the inconvenience of not having the license granted, and in any event, that agreement entered into is a private arrangement between the person who is the grantor and the grantee, as the case may be. And I accept that absolutely. I also say, my Lord and Lady, that the construction of a pipeline and the operationalization of a pipeline must be done only if the licensing regime is satisfied. So if we accept the fact that, notwithstanding the fact that they telegraphed very early they were going to construct a gas pipeline on this piece of land, and in September they obtained the approval, they entered into collaboration with the NGC, who is not licensed as well in respect of this gas pipeline. What we say is the construction of it, because of the technical aspects involved in it, that there's an element of public law here which is triggered, and the element which is triggered is in the public interest and the public good. And therefore, what we have is an illegality, because the Petroleum Act provides a comprehensive regime in the public interest and for the public good in respect of a very highly volatile substance in an economy which is driven by gas and oil. To have regulated every sphere of activity connected with a pipeline, and the Parliament went to the pain of engaging an applicant from the time there's a topographical study to the maintenance of the pipeline by laying out a statutory regime, which must be complied with.
Well, if we accept, for the sake of argument at least, that it wasn't complied with, then you have to develop an argument under the principles set out in Patel and Mirza, don't you, that
Yes.
develop an argument that the public policy requires that private agreement is treated as invalid.
Yeah.
Presumably there's criminal sanctions and other regulatory provisions which could deal with this anyway.
I'll go there. Let me just say one more thing, Milord. The transfer of this facility from KISS to Holiday Snacks is a transfer which has to have the approval of the minister. And might I just take you to that section, which is important, because the regulation is contained in 28 of the petroleum regulations. It's at electronic bundle 1012.
Sorry, section?
Section, regulation 28.
Regulation 28.
Yeah. Now, I would like very much if I set the context here where there is no license whatsoever, but even if there's a license, it says unless the license otherwise provides, an assignment or transfer to another person of the rights acquired and the obligations undertaken shall not be valid without the previous consent in writing of the minister, and any assignment or transfer made without such previous consent shall be null, void, and may result in the forfeiture of the license. I think that goes straight.
Well, that's the pipeline license, isn't
That
it?
goes straight to Patel. It goes straight to.
No, but what's being put to you is that's referring to assignment of the rights acquired and the obligations undertaken under the license.
Yes, my lord.
Not private rights. And
Well, I think
Under the non-existent
yeah,
pipeline license,
yeah, well,
not under the contractual license.
Yeah, well, I think I've gone beyond that point, and we are not dealing with private rights now. We're entering into the sphere of the assignment to holiday snacks.
Yeah, but that's the assignment of the contract. It wasn't an assignment of any pipeline license because there never was a pipeline license.
That is.
So this provision is irrelevant.
Well, my lord, I say this. If there is no license, I accept that absolutely. I accept that absolutely. But the situation is further compounded by the fact that not only is there no license, but there's an attempt to transfer the license from KISS to holiday
No, there isn't any attempt to transfer a pipeline license, is there?
There's an attempt to transfer a facility that is operational, a gas pipeline that is operational, that is outside the regulatory regime prescribed by the regulations, and the person who is operating it is KISS, and KISS purports to transfer that.
This is just a confusion. What was transferred was the right under this 1986 agreement, not under any pipeline license.
Well,
It never existed. And that's your whole point. It never was a pipeline license. There was nothing
my
to
lord,
assign.
Yes, my lord, well, fine. I accept that if that is the position. I just mentioned that to reinforce the issue because.
I see. So you're saying if there was a pipeline license,
That's right.
which there wasn't, then there's still an illegality because there was no approval of the assignment of
Yes,
it to...
it points to the depth of the regulation. It points to the invasiveness of the regulation.
I'm still struggling with whether KISS actually needed a license for what it was doing, given that we know from the agreement that it was Omega Fabricom that actually laid the pipeline, and we know from the September 1986 letter that it was MGC that operated the pipeline in the sense that they owned the pipeline, they put the gas through it, they owned the metering station which measured the gas coming out. So what is it that, I mean, presumably a consumer who just uses gas to cook or whatever in their premises doesn't require a license to do that, and I'm not really quite sure what more KISS did than get the easement, instruct Omega Fabricom to lay the pipeline, and then use the gas that came out of the end of the pipeline. Which of those things amounts to an activity which requires a license under the regime?
Well, lady, I accept, I take your point. It is the fact that KISS is the one who initiated this process for the construction of the pipeline.
But I think you referred to the fact that, you know, we have this regime because gas is a volatile substance. But nothing that KISS was doing in this whole process involved it in anything that could put at risk anybody or anything as a result of the volatility of the gas. I can see that Omega Fabricon might do something which would result in everything blowing up, and similarly NGC, but I don't see what KISS was doing, which is an activity which needed to be regulated for safety reasons.
Well, Omega Fabricon had no independent status to construct any pipeline except at the behest of KISS. They were the agent of KISS.
Yes, but then if I build a house and ask someone to put in a pipeline so I can cook with gas, do I need a license then to operate the gas pipeline?
Yes, milady, because if I may say so myself, this is a manufacturing facility. There is a metering station at the end of it where KISS has this facility, and therefore KISS is benefiting from the fact that there is a pipeline and they are getting gas from this pipeline, and the person who is responsible for that is not Omega, because they would have constructed the pipeline and gone about their business. The person who is benefiting from it is KISS, and KISS is the one who is the party that negotiated the agreement, and KISS is the party who is in charge of the metering station, and KISS is the beneficiary of the gas. That is, someone has to take responsibility. Someone has to take responsibility for an unregulated pipeline which was constructed at the behest of KISS by Omega, its agent, as the case may be.
Mr. Hossain, I'm slightly worried about the time because you haven't yet started upon the other part of your case, which is to challenge the conclusion of the judge and the Court of Appeal that this was an easement. And I know from your helpful summary at the beginning of your submissions that you want to deal with that as well.
Yes.
So I'm inclined to give you a gentle nudge. You only have 15 minutes left of your allocated time to move to that other issue. I hasten to add, you've mainly been answering our questions and doing so very helpfully. So it's not a complaint, but just an encouragement.
Yes, Lord, I accept that. No, I think we have dealt with very substantively with the Mirza point, and the legality issue in our submission, so I'm not going to touch on that. We say it is in the public interest, we say for public purpose, and someone has to take responsibility.
Yes.
And we say the entire operation was illegal, as the case may be. And we have, we say, let me just say one or two short points on that and I'll move on. We say you can't isolate the 1986 agreement and separate it from the rest of the activities which it seeks to authorize. The agreement in itself is in contravention of the statute, but if the agreement is not in contravention of the statute, then any activity which it allows, that is the operationalization of the pipeline, is illegal, and the court should not lend its aid to enforce the 1986 agreement. We say as well, the counterclaim goes directly to that issue. We say the regulatory procedure in the Act and regulations are the public benefit, and the court cannot aid a breach of a statute which is clearly designed for the protection of the public. We say that as a result of that, and Justice Harris himself at first instance found that the operationalization and the construction of the pipeline was illegal. Now I'll take you to the other part of my submissions, my lord. I take the hint. We say also that finally in Neverson, we invoke Neverson, and we say you can't establish an easement to do something which is prohibited by statute. That is to construct, or alternatively to operationalize a pipeline with gas which is heavily regulated. And this is not in the private sphere, it is in the public sphere. That is a regulatory activity, and we have to move respectfully away from the issue of whether it is a private right into the sphere of a public responsibility. Now, we say that when we look at the agreement, that is the agreement struck between Mr. Boodhai and KISS, and that agreement has already been provided to Millards,
Yeah.
Milady.
256.
256.
Yeah.
256. We say the following features stand out. First of all, we say the agreement states that it is for the benefit of KISS, and that's a personal benefit because KISS's property is not identified in the agreement at all. The agreement does not identify a dominant tenement. Only the address of KISS is provided, and we say more so we invoke the Starham case, and we say the agreement makes no attempt to link Mr. Boodhai's property to the space occupied by KISS so as to give it the flavor of an easement. Although we accept the fact that extrinsic evidence can be brought in, we say in a situation where the words of the agreement are plain. This is at most a contractual license, and external evidence cannot be brought in to contradict the plain meaning of the agreement. And this is exemplified by the fact that KISS subsequently used this gas and took it to another location, one lot away from it. That is to Holiday Snacks Limited, and thereafter for 3 other businesses. Now, the court is well aware of the Regency case, especially Millard, the president, and it must attach to the dominant tenement. And if it's an easement, and it attaches to the lands which are described in the agreement, it attaches to that land alone, and therefore this easement cannot be extended further down the El Socorro Road as it was done.
Now that extension of use occurred sometime after the agreement was made, did it?
After the agreement was made.
Can you give me a date? You may not know.
Yeah.
Come back to it by all means.
Yeah, we can come back on that. It was extended to at least 3 other commercial properties down the road. So therefore, it was in the nature of some kind of contractual license rather than the nature of an easement. And we use Starham and we use Ellenborough, and we use all the cases that are important in that regard. What is required is more than just an address of KISS. What is required is that the dominant tenement and the servient tenement ought to be described with some degree of precision, or otherwise it does not attach. Lord Parfit in Starham says the language makes no attempt to grant the rights over the blue land to be a benefit given to the owners of the red land, right? And that is exemplified by the example I gave. Now, furthermore, it can't be that this is capable of an easement because of the fact that the regulation 15.1 says in any event, if you are given a license to conduct a pipeline, to run a pipeline, because that is what is intended by the easement, the maximum period that it can endure for is 20 years. And therefore, you can do 10-year renewals. So you can't have an easement that is in violation of the regulatory standard that is established by the regulations. And this is where we bring in Neveson and Peterborough, because we say that the operationalization of the pipeline, the intended operationalization by KISS, was clearly designed to run a gas pipeline, and therefore it was in the nature of a contractual license. The fact is, a contractual licensee means it's an agreement between Mr. Boodhai, and KISS. And Mr. Boodhai, that is gleaned from the agreement itself, and it is also gleaned from the fact that the ingredients of an easement were not satisfied. Now, one letter which I think that it is important that the court should look at is contained.
Just before you move away from the agreement, you helpfully said that you accept that you can use extrinsic evidence to identify the dominant tenement, but not to use it to contradict the agreement.
Yes, my lord.
Now, let's assume that there was evidence as to neighbouring land owned by KISS at the time of this agreement, which might be sufficient to satisfy the extrinsic evidence test for identification of the dominant tenement. If that were so, what, if anything, in this agreement would it contradict?
Well, I take that point, my lord, but I take that point. But
it's a question.
Yeah, the question is that not only contradiction, but supplemented to the point where there's a massive deficiency in the agreement. And the deficiency in this case is that the essential critical ingredients are not there. So what the court might not want to do is to compose an agreement.
Okay, so your submission is you can use extrinsic evidence to identify the dominant tenement, but not either to contradict the agreement or to supplement a massive deficiency in it.
That is so, my lord.
Okay, thank you.
Yeah. Mm-hmm. Yeah. Now, what we have here is in the agreement, Mr. Boodhai also agrees to allow any approved agent of KISS to conduct repairs to the gas line on this property should any repairs become necessary in the future. Now, if that is an easement, it means for an unlimited period of time that Mr. Boodhai and his successors in title would have to allow persons whom KISS may sell the property to, if it attaches to the land, to conduct repairs in a manner which is not under his control whatsoever. And one can hardly imagine someone who lived on those premises would now, in perpetuity almost, over a considerable length of time, allow someone to come onto these premises to conduct maintenance work in respect of that,
Well, you would think that he would want that, actually, because if he's got a gas line running through his property that's become effective, isn't it in Mr. Boodhai's interests that KISS is undertaking to make sure it's kept in repair? It's Mr. Boodhai who's at risk if there's something wrong with the pipeline.
And this is why we say it's a license, lady. I could understand Mr. Boodhai agreeing to that if it's a license.
The owner of the land. But isn't it just as much as in the interests of a successor entitled to Mr. Boodhai that KISS or its successor in title is undertaking in the agreement the responsibility of repairing the gas line that's under?
Well, I would not think, lady, if we measure the level of intrusion that is going to occur on Mr. Boodhai's land for the foreseeable future in a place where he lived, that for some time thereafter, for a considerable period of time, that he had this intention to do that, because it will constitute a very high level of interference. I can understand if he says, look, it's a license, terminable with reasonable notice. I can allow someone to come and do my repairs to my pipeline, to the pipeline as the case may be, but not forever and ever as the case may be. Yeah, and especially if it's transferred to other persons. Now, so we say the plain reading of it is that it is a license. We say also a contractual license cannot bind a third party, even if the third party has notice of the contractual license. And we say as well that it cannot create any kind of constructive trust. And we, in respect of the first proposition, we rely on Ashburn, and we rely on IDC and Clark for that proposition. In respect of the issue of the constructive trust, we say that in order to establish a constructive trust arising of a license, you must have special circumstances, you must have certainty, you must have a situation where the conscience of the transferee is affected. We say it must be exceptional. We say it does not matter whether Mr. Boodhai or Energizer, for that matter, knew of the fact that there was a license in respect of this parcel of land. That does not matter. And we say Section 16 of the Conveyance and Law Property Act does not pass a contractual rights of KISS in the conveyance to Energizer, as the case may be. It is not, the section cannot pass it because it's Section 16 and it's not contained in the deed, as the case may be.
Sorry, where do we find Section 16?
Section 16 of our Conveyance and Law Property Act.
I think it's set out in either your or your...
Yeah,
in your written case.
In our written case,
Yes.
yeah. Now, I don't know, I mean, my time is up.
I'm afraid so.
Yeah, so I rely on Millard's term.
I'm afraid so, Mr. Hussain, but
Yeah.
we have got your very full written case as well.
Thank you, Millards.
Fully understand that you rely on every word of it.
Thank you very much.
Thank you.
Much obliged.
Yeah.
I think the board will take a few minutes to see where we've got to in the case so far. So we'll adjourn for 5 minutes, please.
Much obliged, Millards.
Mr. Sookram, the board has considered where we've reached, and we've decided we don't need to trouble you. We're most grateful to both you and your junior for being here.
Much obliged to you.
We don't need any further assistance from you beyond what's already, of course, in your
Thank you, Millards. Much
extensive
obliged.
written case. The board will take time to consider its judgment in this matter. Thank you very much, both teams of counsel, for some stimulating arguments, written on your side, written and oral on yours, with which we've been very greatly assisted, and your very frank and helpful response to our questioning, which has been of great assistance.